Welcome to EU Privacy for All, Session 24 on GDPR, Article 48, Derogations regarding data transfers. In the GDPR published on 4 May 2016, the derogations for specific situations regarding data transfers were framed in Article 49. This article provides that in the absence of an adequacy decision or in the absence of any kind of appropriate safeguards, including BCRs, a transfer or a set of transfers of personal data to a third country or an international organization shall take place only on one of the following conditions. The data subject has explicitly consented after having been informed of the possible risks of such transfers of data. The transfer is necessary for the performance of a contract between the data subject and the controller. The transfer is necessary for the conclusion or performance of a contract concluded in the interests of the data subject. The transfer is necessary for important reasons of public interest. It is necessary for the establishment, exercise or defense of claims. Or the transfer is necessary to protect the vital interests of the data subject or of other persons where the data subject is physically or legally incapable of giving consent. And the transfer could also be allowed because of being made from a register. Where a transfer could not be based on a provision in Article 45 and 46, and none of the derogations for a specific situation would apply, a transfer to a third country or an international organization still can take place, but under the condition that the transfer is not repetitive, concerns only a limited number of data subjects, and is necessary for the purposes of compelling legitimate interests pursued by the controller, which are not, additional condition, overridden by the interests or rights and freedoms of the data subject. And additionally, the controller will have the obligation to assess all the circumstances surrounding the data transfer, providing suitable safeguards. The controller shall inform the supervisory authority of such a transfer, and the data subject on the compelling legitimate interests pursued. Article 49 also provides that a transfer shall not involve the entirety of the personal data or entire categories of personal data contained in a register. It also clarifies that consent, contracts, and legitimate interests shall not apply to activities carried out by public authorities in the exercise of their public powers. The public interest, additionally, must be recognized in the union law or in the law of the member state. And, in the absence of an adequacy decision, union or member state law may, for important reasons of public interest, expressly set limits to the transfer of specific categories of personal data to a third country or an international organization. Finally, the controller or processor has the obligation to document the assessment as well as the suitable safeguards implemented. Some additional information are provided by recitals, notably recital 111 on the fact that transfers could take place in certain circumstances where the data subject would have been giving his explicit consent, or when it is occasional and necessary in relation to a contract or legal claim, or for important grounds of public interest, or related to a register. Recital 112 specifies the important reasons of public interest. It could be, for example, international data exchange between competition authorities, tax or customs administration, financial supervisory authorities, services competent for social security matters, public health, or, for example, in the case of contact tracing for contagious diseases. It is aimed to protect an interest which is essential for the data subjects or another person's vital interest, and the Union or Member State law may, for those important reasons of public interest, expressly set limits to the transfer of specific categories of data. Recital 113 underlies the fact that transfers which can be qualified as not repetitive and that only concern a limited number of data subjects could also be possible for the purposes of compelling legitimate interests. In such a case, the controller should give particular consideration to the nature of data, the purpose and duration of the proposed processing operations, as well as situation in the country of origin, the third country, and the country of final destination, adducing suitable safeguards. Such specific transfers should be possible only in residual cases where none of the other grounds for transfer are applicable. Finally, Recital 114 provides that the controller professor should make use of solutions that provide data subjects with enforceable and effective rights. In Article 26.1 of the Directive, mainly are provided derogations that are also laid down in the GDPR, that is to say, consent, performance of a contract between the data subject and the controller, contract concluded in the interest of the data subject, public interest, vital interests, and in the frame of a register. What should accountable data controllers and processors get prepared for? First, they should identify when no adequacy decision is taken and no adequate safeguards are offered. Then, envisage lawful derogations, consent, contract between the controller and the data subject, contract concluded in the interest of the data subject, public interest, vital interests, register, and the establishment, exercise, or defense of legal claims. If none of those derogations apply, for compelling legitimate interests pursued by the controller, and that would not be overridden by the interests or rights and freedoms of the data subject, transfers might take place whenever they are not repetitive and concern a limited number of data subjects. In such a case, adduced appropriate safeguards should be guaranteed, and DPAs and data subjects be informed. Controllers and processors will also have to bear in mind that EU or national law may, for important reasons of public interest, expressly set limits to the transfer of specific categories of data, and they should provide data subjects with enforceable and effective rights. So the question comes now about upcoming EDPB guidance, and notably regarding compelling legitimate interests.